Welcome to another section of Women and ADR podcast. My name is Lady Nancy Abuaji, and I'm here with Dr. Mrs. Ayunati, who is an ADR practitioner and also a member of Women and ADR. I also have the privilege to have Madam Asana Mohammed, who is a legal practitioner, ADR practitioner, and also a member of Women and ADR. Ladies, you are welcome.
Thank you very much.
Okay. Today we're going to look at Court Connected ADR. Said we have two forms of dispute resolution in Ghana. We have the ADR process, and we also have the normal traditional litigation, the one that we do trials in court. And ADR, we have the Court Connected, which is attached to most of the courts. So we're going to look at the processes, what happens at the ADR. If someone that I want to go to ADR when the person appears in court, what are the processes that they have to go through? Doctor, let me find out from you. If someone gets to court and says that as we are preaching or advocating for ADR, and the person says, okay, I don't want the normal litigation or the traditional litigation in court, but my case, I want it to be settled at ADR. What should the person do?
Yeah, that's very good. The person walks to any court in Ghana now, district, circuit. Yes, he goes to the registrar's office and tells the registrar about it. Well, if he has written the case down already, fine. If not, he has to go to Commissioner of Oath. They help the person type out the case and everything, bring it back to the registrar. It will be put on a file. And then they will have to give the person a date for hearing, but they will have to serve the other party and let the person also know about the date for hearing. So a file is open, a date for hearing is set, and then the parties come to court on that day. If they get there on the day of the court, the judge would have read through the file already. So he knows that they have requested for ADR. And if he sees that the case is okay for ADR, he would say refer to ADR. Then the parties go to the ADR session.
Okay. Let me ask Lady Asana, are all cases appropriate for ADR? Because said the judge will read through the case and can recommend that you have to go to ADR. So what are some of the cases that are amendable to ADR?
So not all cases are amendable to this. So when we go to the Act says that all cases except one that border on public policy or the interpretation of the Constitution or environmental matters. But aside that, within the court, we have three main domains of cases that border on civil, matrimonial, and criminal.
Okay.
All of them are amenable to ADR. And then, but when it comes to the criminal matters, there are ones that border on misdemeanor, small crimes, and then
small crimes.
Assaults that are not aggravated in nature. So the court or the judge will do that determination and say, okay, this crime is not that one that requires that we do a criminal trial on. Or there are certain cases where even the prosecution do not have any they don't have evidence to back up that. Sometimes the accused persons might be in remand for 2 weeks, 3 weeks. Prosecution is not forthcoming with. And the judge has that power to discharge the person because there's so those cases sometimes.
So felony cases don't go to ADR.
So those cases sometimes are brought to ADR so that the parties can have a closure to that matter in terms of the criminal cases.
Okay. So now let's look at as the judge has or the magistrate has referred the case to ADR outfit. What happens there?
Yeah, when they come to the ADR office, you welcome them, make them comfortable, because now it's only the parties, no witnesses are allowed in ADR session. So the parties are there. You first of all check with them if they know anything about ADR. If not, you give them a small briefing about ADR and let them know that even though the judge said they should come to ADR, they have to consent to that. So you explain the consent to mediate form to them, that it doesn't mean anything. This is the form. We need your name, your signature, and your telephone number. just on the consent form that you have been asked to come to ADR. Both parties will sign, the mediator too will sign. It is very, very crucial that in any case, a consent form is signed. The implication is that at the end of the day, if anything comes out of the situation and the judge finds out that no consent form was signed, the terms of settlement could be set aside.
Oh.
Yes, it's that serious. So in any case, a consent form, and we write consent to mediate.
Consent to mediate. So meaning that like one party can just get out that you didn't seek my consent and you mediated, so I would not accept the settlement.
Exactly. So you have to, that is why it's needful to explain the ADR process the mediation process to them, why they have been referred to ADR, and why they should sign the consent form. And when they agree, you let them sign. Those who don't understand English or cannot, we get what we call a jurat. Somebody to interpret for them in their local language. Those who cannot sign, they thumbprint, and we indicate right thumbprint or left thumbprint. These are all necessary elements we put on the consent form.
Let me go to Lady Asana. What are some of the rules of a mediator when the parties come? What do you do? A doctor has explained one, as you explained the consent form for the parties to sign, and it's very, very necessary as a mediator that you must follow that part. What else? What are things that you, the mediator, you have to do to make the session very successful?
Okay, to add up what Doc said about the consent form, one of the other reason also is that when in courts, the order to attend the ADR process is an order of the court. So the consent form also is like a validation of the respect that the parties have given to that order. Because even though it's a voluntary process, they can opt out after they have agreed to be part of the process. Within the process, they can opt out, and it is their right to do so. So as a mediator, again, your role, as Doc said, is to educate the parties on ADR and then to also facilitate communication. Because in every dispute situation, the parties most of the time come and they are adversarial towards each other. So it is one of the skill of the mediator to get the party. Sometimes you work the way you welcome them, how you entertain them, and all that. They even forget that they are fighting. So it's one of your roles. It's a skill that every mediator should have to be able to facilitate communication. And also, you are also an evaluator. You evaluate the kind of disputes that they have brought before you. So sometimes you even inquire from them. Why are you here? What is the reason why you are? What do you want from the court? So you evaluate and understand the gravity of what they have brought before you. And then at the end of the day, you act, because you act as a conciliator. Again, you find ways,
them.
Or you manage even when the parties, because at that point they are negotiating. So you are the manager of the negotiation that is going to go on between them. Because sometimes in negotiation they say things that are not appropriate. Like some of the things that we stop them from saying, you are a liar. You are a wicked person. And those words cannot allow reconciliation. So sometimes we manage the emotions and some of the things that they say to make sure that the process goes on smoothly. Because at the end of the day, what is your goal as a mediator is to facilitate communication and then get results by reconciling the parties.
Let me ask Doctor, as I think she mentioned of manage emotions and sentiments. Have you perchance met a case that the person started crying and showing that emotional or sensational? How do you manage that?
As a mediator, you have to be very careful not to be carried along, because when they are showing that emotions, crying and everything, they are also watching you. And the other party is also watching you. And that is where the neutrality of a mediator comes in. You may offer tissue, empathize, but you are not carried along with what is going on. And you see, as sometimes even in crying and showing, you say, whatever the other person said is a lie. No, I don't want to hear that side. Stick to your side. You see, they want to, mediators, we have to be very careful. The parties want to draw you into the situation. So you have to be very careful and say you are working on a thin line. When this let's say a lady is crying and a male mediator, if he's not careful, he shows some sentiment. The other, so now they are losing confidence in the mediator. Yeah. So you have to stay neutral, empathize, can give a tissue if you have one, or give them a breathing space.
Okay.
You know, sometimes I encourage them deep breathing. Breathe for some time. How do you feel now? Are you okay? Okay, clean your face. Let's continue.
Let's continue.
You see, and then they are comfortable and they have confidence in you.
Yeah, okay.
You are managing their emotions very well, which is very important as a mediator.
That is good. That is good. Let me go to Lady Asana. Let's look at as we're talking about the role of the mediator. What is the role of the parties?
Okay. So when the parties walk in, as Doc said, we take them through the rules, because the court works with rules. The mediator also works with rules. So when they come in, we tell them that they are obligated to respect the rules, so that the process will run smoothly, and the mediator will also be able to work efficiently with them. And then the parties are also obligated to communicate with each other, because without communication there can't be a process. And then they are also, at the end of the day, to waive off their positions. If you hold positions, you can't resolve issues. What are the interests? What are the common grounds? Where can we meet each other? So the parties must be minded of that. And then again, when it's in court too, it is not just them. There are a lot of people there. So we should be mindful that we work with time. So they should respect the time that has been allocated for them to resolve the issues. And at the end of the day, they respect each other. Okay? They are empathetic towards each other, and they are self-aware of the environment, and then at the end of the day, to respect to the mediator who is there to help them resolve their
case. Let me.
Okay,
you want to
say
ask
something about the parties in the mediation? They are sitting arrangements. Which is very, very crucial. We always do our best not to bring them together. You know, the mediator stays in the middle, one party on the other side and this party on the other side, because sometimes it gets to a point that, tensions are there and we don't want anything to happen.
Throw the hand.
Yes. Even some people by nature, when they are talking, they are expressing, and if it's so close by and the hand hits, that's another conflict. So we separate them.
Okay.
We let them sit a distance that is comfortable. Yeah, sitting arrangement in mediation is very, very important.
Very, very important.
Yeah.
The question that I wanted to ask was, I think Lady Asana mentioned of the interest, what they want, but let's look at a situation whereby one party has taken an entrenched position and doesn't want to come down. As a mediator, what do you do?
Yeah, there's something in mediation we call caucusing. At this point, the mediator can take the party out of the room, because by the rules you will tell them that there will be a time of caucusing, so they are aware of it already, and then you go and explain to their party the cost. If they begin to understand, if this situation is delayed, now you should be at office or work or somewhere, you are here, and you keep coming to court, you are wasting your time, transportation and everything, and you are losing. If you have to go back to court and get a lawyer, what are you going to pay for it? Maybe the money you are asking for is X amount. We resolve this, you get your money and it's done. Going up and down for a week, a month, and two, calculate that cost too, so you are at a loss.
Yes.
So why don't you come to a compromise? Compromise doesn't mean you've lost, because all you know is lose-win. But this is ADR, it's a win-win.
Okay.
So whatever you are asking for, you may not get the 100%, but you get something that is comfortable.
Yes.
And it saves you time, and then, so after you have explained this to the person in caucusing, he sees that he has mellowed down and he's able to now compromise with the other party.
Now let's look at, as a mediator, you've spoken, they've spoken, and now they've come into compromise, as Doctor was saying. So then what next? What do you do? Because now you've seen that there is a leeway of settling the case. So what do you do?
Okay, so as a mediator, you can inquire from the parties that, from their conversations, you have realized that they want to do A, B, C, and D. Is that when is that what they want to do to resolve their matter? If there's a consensus from them, then you try to tell them, okay, from your conversations, I realize that you want to do A, B, C, and D. Or if there's probably, for example, a debt to be paid, you want the party, the one who is asking for his money to give you time. Because most of the time, every debt collection matter, you realize that time, give me time to pay. Okay, so sometimes the parties will say, oh no, me, the money he has taken it for 10 years ago, so I won't give him time. But the thing is that what we should let audience also understand is that if you bring a matter to court on debt collection, the court will still allow the party to pay in installment because it's according to how the person can pay. So we allow them to say, okay, even when the matter goes to court, this is how the court will still schedule it, but it should be within a reasonable time. Yes, so when the person agrees, you draft it on paper for them, you read it to them for them to understand. This is how you say you want to resolve. Is that it? When there's an agreement, you allow them to sign. You sign, and then the matter goes back to court
for adoption. Okay, so let me ask you, has it been a case where you settled a case, that you know that you have settled a case, but the parties in a time of adoption, they said, no, we don't want the settlement again, and for that matter, we don't. Well, have you experienced that?
It happens to every mediator.
Why that?
You know, sometimes is two parties involved. And as we said earlier, positions. So sometimes if the adoption is not immediate, sometimes the adoption is immediate, sometimes it's not immediate. Usually when it's immediate, there's not much rancor. But if it's not immediate, the parties are asked to come back the next day. They go and have a conversation with somebody. Oh, when we went to court, this is us. You
accept it. You shouldn't have accepted it.
He's using 1 year to pay your money. No, don't accept it. And when that happens and they come back to court and they tell the judge, why is the judge? Because the mediator's work, the judge cannot usurp the work of the mediator. So even if you write your settlement and you don't dot a T, then the judge cannot put that dot there.
No.
Yes, so when the parties come, the judge is not part of the process. And the judge cannot ask you to inquire what happened within the process. So once one party raises a bias, they will have no option than to step down the terms of settlement.
Wow. But I think I read from somewhere that if you read it to them at the mediation process severally and they agreed and signed, it's binding on them. So when they go back to court and said, we don't want it again, the judge should not allow them that they should have to go back. They have to continue with the process because nobody forced them. Unless they said, maybe someone forced me and that is the reason why I can't do it. But if they agreed at the mediation process, read it to them for them to understand and decide, they cannot go and
most of the time too, it depends on the circumstances.
It depends on the circumstances.
Because sometimes the judge will inquire and inquire. And sometimes they'll even call in the mediator, in extreme cases, call in the mediator to testify.
Don't you think some of them just want to go and lie because
the
it
human
didn't go
nature.
their ways? Or
The
as you
Act-
said,
the ADR Act says that the judges should adopt the cases immediately.
That is
knowing
how it's supposed to be.
of these challenges, they should adopt immediately. And if they don't, I had a case when the parties came back. So the judge called me in chambers. They said they don't want to. They have changed their mind or something. He called me in chambers. And I asked them, did anybody force you to sign? They look at each other. The judge was observing us.
Yes.
And they said no. So I asked them, so what happened? They said, then when we were going, when they were going, the other one made a comment. So that annoyed him, and that's why. So the judge said, no, once you have signed
you have signed,
you have signed.
You have to
You
go
see,
like
that is why the ADR settlement cannot be appealed. So I always take time to read my settlement several times to the parties, interpret it in all the languages I
that
can.
you understand.
And I said, once you sign, you see, we cannot tipex it. We can. It's your signature, and it remains forever. So even in the terms of settlement, now we have been encouraged not to even tipex anything. If you make a mistake, you rewrite the whole thing. You don't cancel anything. You have to. So when you are writing terms of settlement, you have to be very,
Very
careful.
careful.
Write everything. Where there should be full stop, you do it, and everything. And if there's extra space, you rule out.
Yes.
So that
Then
nobody
you
can
sign.
and add anything. Terms of settlement is very, very crucial, very important, and it's a legal document.
Okay.
So it has to be taken carefully. And let the parties, I always explain to them, you cannot change anything here.
Anything in there.
So make sure you understand and everything they sign. I said, tomorrow if you come back, it
You
will
will
not
be
be
changed.
changed. So it's very
Yes,
important.
it's very.
Yeah.
Let me ask so do lawyers participate in ADR process?
No, lawyers are not allowed to unless under certain circumstances. For example, if probably the client is somebody who is not too mentally stable. In circumstances like that, the lawyers may sit in for them. Or even if they do, they are just observers. They're not part of the process. And most of the time, to even erase confusion, they are exempted from the process.
If they raise confusion. But I read from somewhere that the lawyers sometimes help with a settlement because they're able to speak to their client
Clients.
effectively for them to consent to some.
Sometimes.
Yes,
That's usually doesn't happen most of the time.
Most of the
Yeah.
Per
time.
experience. Yes, per experience doesn't happen most of the time. So we'd excuse them. Sometimes if the party say, oh, I want to consult with my lawyer on this one before I even allow that to be entered into the settlement, then you can allow them to say, okay, consult. And I've had circumstances
but
where
some lawyers can represent their clients.
when the clients, because sometimes the clients are outside this
yes,
country, so we do sometimes an online version of the
Okay.
process whereby the clients will be called and be on speaker, but the lawyer will be representing because the person is not around. There are so many instances I've done that.
Okay.
The lawyers are present, but we call, even with that, we still need the consent of that person to resolve the issue.
Okay. I think it's getting interesting, but because of time, we have to end here. Today, we were discussing the processes that goes on when we have Court Connected ADR. And with me was Dr. Irene Nate, who is an ADR practitioner and also member of Women and ADR, and also Madam Asana Mohammed, who is a legal practitioner, ADR practitioner, and also member of Women and ADR. See you next week. My name is Lady Nancy Abwaji. So now let me give you the number. If you want further clarifications or further explanations of what we discussed today, you can call 027 809 8704. 027 809 8704 or 024 666 4770. 024 666 4770. Or you can reach us on our social media handles, Facebook Women and ADR, also on YouTube Women and ADR, or with our email women.adr@gmail.com. You can contact us if you want to get any further clarification. If you're a woman, you have been trained to become an ADR practitioner and you want to be mentored, you can call. If you are not an ADR practitioner but you want to join, you are welcome. You also have issues, either your marriage, child maintenance, anything, you can call and it will be at you. Thank you.